Good evening, good morning, good afternoon, everybody, and welcome to this public lecture in this Peking University School of Transnational Law, 北京大学国际法学院, public lecture series. For those of you who are not familiar with our law school, Peking University School of Transnational Law, we also refer to ourselves as STL for short. S School, T Transnational, L Law, School of Transnational Law. Apologies for our starting a little bit late today, but we're glad that everybody is here. My name is Norman Ho. I teach in the law school, and it's my great pleasure to welcome you and to welcome our speaker, Professor José Alvarez. Professor Alvarez serves as the Herbert and Rose Rubin Professor of International Law at New York University School of Law, or often known as NYU Law. He also serves as faculty director of the U.S. Asia Law Institute at NYU Law. And prior to joining the faculty at NYU, Professor Alvarez taught at Columbia Law School. He's a well-known international law expert and has served as president of the American Society of International Law and has also served as co-editor-in-chief of the American Journal of International Law. He's published numerous books. Some of his monographs include The Impact of International Organizations on International Law, which came out with Brill, International Organizations as Lawmakers, which was published by OUP, Oxford University Press, and most recently, with his co-author Judith Bowder, Women's Property Rights under CEDAW, which came out with Oxford University Press just this year, 2024. And Professor Alvarez will be our main speaker tonight, and he will be speaking on the topic of can international investment agreements advance the sustainable development goals of the UN. I would also like to introduce our discussant, who will offer brief comments after Professor Alvarez's lecture. Our discussant this evening will be Professor Asif Qureshi, who is a professor of law at Peking University School of Transnational Law. Prior to joining the Peking University faculty, Professor Qureshi taught at Manchester University's Law School in the UK and also Korea University's Law School in South Korea. He's also an international law expert, has published numerous books and articles. His monographs include Interpreting WTO Agreements, Problems and Perspectives, which came out with Cambridge University Press, Contextualizing International Law in Northeast Asia, which came out in Hart, and The United States and the International Economic Order, which came out in Routledge. And so we're very honored today to have both Professor Alvarez and Professor Qureshi join us. So the format of this event will be this. Professor Alvarez will first present his lecture for approximately 40 minutes, after which Professor Qureshi will offer comments for about 10 minutes, and then we'll open it up to Q&A. So Professor Alvarez, over to you. Thank you so much.
Thank you, Professor Ho and Professor Qureshi, for arranging this. I'm very grateful and honored, and also a good opportunity for me to become familiar with STL, which sounds like an incredibly impressive and unique program. I'm sorry that it has to be on Zoom and not be there physically. So as the title indicates, my talk, which is based on a series of work that I hope will be published soon, tries to connect international investment agreements or the investment regime with the UN's Sustainable Development Agenda, which is a huge part of what the UN has been doing when it comes to development, and connect two enterprises that you would think would be linked, but they're actually less linked than you might think. And so I'll start with something that I think might be familiar to most of you, which is these are the Sustainable Development Goals. They replaced the Millennium Development Goals, or MDGs, which concluded in 2015. They're exceedingly ambitious 17 goals to advance sustainable development that are supposed to respond to persistent growing inequalities, adverse social ills, environmental degradation, and frankly, in many ways, they are intended to respond to market capitalism including, I would say, the next slide, which I will show you shortly, which is the international investment regime. So in some ways, the SDGs are a response to the perceived problems or challenges posed by prior attempts to promote economic development. And so the SDGs favor, instead of directly relying on just the market for economic development, they see this as a way to promote proactive government policies, including through the UN system itself, in favor of these 17 exceedingly ambitious goals. And what I would say is, even though the goals sound rather lofty, uh, because of the programmatic nature of them, it's not just 17 goals, it's 169 targets that are divided up into the goals and 231 indicators of success. They're actually a bit more precise in terms of the policy goals that governments are urged to do. Unfortunately, at least from my perspective as a lawyer, the initial approach, which was to ground these in legal obligations that states have, including under international environmental agreements, international human rights commitments that they have ratified, that initial stance was abandoned as states did not want this to be associated with legal obligations. And so the SDGs are now known in the UN as desirable policy goals. And I think that has, to some extent, actually hurt their implementation. But just to give you a sense that they are a bit less lofty than they appear, that is, they're a little bit more precise. And poverty, for example, goal number one among the indicators are to eradicate extreme poverty as measured by the proportion of your population living on less than $1.25 a day, which is the international poverty line. Goal three on global health is to reduce global maternal mortality ratio to less than 70 per 100,000 live births, and also to end preventable death of newborns to less than 12 per thousand. Gender equality, and a very important goal, number five, is to end all forms of discrimination against women and girls. Well, that's lofty enough, but some of the indicators are quite tangible. That is, do you have legal frameworks in place to promote, enforce, and monitor equality and discrimination against women? So what I want to suggest by that is that these goals are originally designed to give effect to legal obligations of states, but over time they have been associated with simply policy goals. And I think that's one of the problems, in addition to the manifest difficulties that I will talk about funding these efforts. That is, it takes money to achieve these goals. And some of the money was supposed to come this way. This is the international investment regime as usually portrayed through the spaghetti soup mix of all of these bilateral treaties. Some are just between two states, most of them, and regional agreements such as the Trans-Pacific Partnership or the African Continental Free Trade Agreements Investment Promotion Protocol. And what's the advantage of this particular chart produced by UNCTAD is that it gives you, by the circles, the states that have the most number of bilateral investment treaties. So you see China looms large, Switzerland looms large, but otherwise, this regime, as many of you might know if you've studied investment law, was largely promoted during the 1990s. At the end of the Cold War, when states turned to the market and encouraged by model bilateral investment treaties promoted by capital exporting states, such as the United States and Europe. Today, the treaty is, at least officially, over 3,000, but those treaties that are actually in force number around 2,500. And what you see in this chart that is also useful is the green part, the green spaghettis. And those represent the more reformed international investment agreements that have been entered into mostly, I would say, in the past 15 to 20 years. And I will talk about the reform of them over time. But keep in mind that those not familiar with the investment regime is the traditional investment treaties, the ones that are not in green, sought to protect capital flows and therefore economic development, principally from capital exporting to capital importing states, by extending them substantial guarantees, including the right to sue under these treaties, under international investor state dispute settlement, or ISDS. What are the protections? Fair and equitable treatment, national MFN treatment, free transfers of capital so that capital can be brought in and out without discrimination, and a guarantee against direct and indirect expropriation. Those were the traditional treaties. The reform treaties, which I will discuss in a minute, still contain some of those guarantees, but have, on the whole, increased the possibility that host states can use more of their policy discretion, on the view that, as suggested by the next slide, actually the investment regime, and with apologies to William Blake, who did this long before the investment treaties were in place, represent and look like two hydra-headed monsters, the top one being the international investment agreements themselves, and the bottom being the way they are enforced, the ISDS, Investor State Dispute Settlement. For those of you, with apologies to those of you who have studied this, but let me just briefly mention what the critiques have been. That is, the larger monster, the international investment agreements concluded during the 1990s, were portrayed as being basically a treaty-based version of protecting the Washington Consensus model, and that in the views of their critics, there really was no need to extend so many treaty protections to foreign investors. They did not face an obsolescing bargain when they entered into this and sunk their costs. That is, most states did not treat them as poorly as portrayed. They did not really suffer from a liability of foreignness or discrimination, and therefore you didn't need to give them national and MFN treatment. The other critique is that once these countries entered into these agreements, they found that they either did not actually attract foreign investment, or they attracted the wrong kind of foreign investment. That is, the negative externalities of the foreigners brought in with all of these protections meant that they lowered environmental standards, they did not pay their workers sufficiently, they did not respect labor's right to organize, and that they did not improve the economic development of these nations, but actually promoted the capital flows to the benefit of the capital exporting states. The claim also was that they did not really improve the national rule of law as advertised, and that they precluded the host states from securing the benefits of FDI, such as old-fashioned performance requirements. These treaties generally meant that a state could not extract technology from the foreign investor, could not demand that they export more than they import, could not demand that they use national resources or national companies as part of their models for creating wealth, and that they generated regulatory chill or under-regulation so that the host state was not able to do public policy protections, including enhancing protections for the environment, because any time they tried, they would be sued for violations of the treaties themselves, and that they basically, in the words of their harshest critics, perpetuated the West's civilizing mission and exported hegemonic views of what international economic law should be. The bottom monster was equally criticized. That is the reliance on investor-state arbitration. This made everything worse because and here I'm being as impolite as I as the critics have been, the arbitrators consisted of stale, male, and pale arbitrators from a particular set of countries that only took a particular asymmetric view of the treaty's interpretation, always ruling or mostly ruling in favor of investors in derogation of sovereigns' right to regulate. They generated inconsistent, fragmented, unstable law across the multiple proceedings. It was treaty shopping galore. The arbitration process lacked a full corrective appeal process. Even under ICSID, there was only an annulment proceeding. There was lack of assurance of arbitral independence. It was insufficiently transparent, especially with regard to who was actually funding these challenges to host states' regulation, that is, third-party funding, insufficiently participatory in light of concerns by civil society, and extremely costly and time-consuming. So these two hydra-headed monsters has led over the past 10, 15 years to a considerable reform agenda, both in UNCTAD and UNCENTRAL in particular. And these are just a brief overview of the 10 favored options. And I would stress the ones in red on this table. And in particular, UNCTAD stressed the need to replace those outdated treaties that were unfairly favorable to investors in the view of their critics, and unduly unfavorable to host states' regulatory discretion. So you see here replacing the outdated treaties, or perhaps terminating international investment agreements, or if you can't terminate the top monster, at least terminate the bottom one, eliminate investor-state arbitration, or reduce its scope by limiting the number of claims, by saying that there was a statute of limitations, of a whole variety of methods. And so these are the 10 general options, but more particularly, and I think more importantly for the purposes of my talk today, this is from UNCTAD's Investor Policy Framework for Sustainable Development, released in 2015. This is the more precise recipe book for those green treaties portrayed in my second slide. That is, if you want to reform these treaties, ostensibly to benefit sustainable development, which is now stated as a goal in the preamble of these treaties, you do a number of things. You can group them in these three categories. If you look at the left, the first category is change the preamble, change the language of the investor rights, change the language of the carve-outs or reservations that states have to make sure that you better protect and safeguard the policy space of host states, and you limit the possibility of states being sued, sometimes for millions and millions of dollars, for violations of these treaties. And the more precise recipe book in that first category includes, for example, saying that this does not cover indirect or regulatory expropriation, or omitting the fair and equitable treatment standard altogether, which frequently led to investor wins more than any other category, preventing the abuse of investor-state dispute settlement by preventing states from engaging in treaty shopping, where they would incorporate a paper by paper in one country only to take advantage of that country's network of bilateral investment treaties, omitting other portions of the protections, including the so-called umbrella clause, and then adding other new provisions, which is the second category on the left, that is stronger ideas of actually suggesting that investors have corporate social responsibility standards, have an attempt to look out for compliance by those investors of those standards, and trying to promote home country, that is, from the capital exporting states, support for a better approach to the investors who go abroad. And lastly, the last category of reforms is basically being more sensitive to the position of the least developing states, including special differential treatment, so that in the cases of the poorest states, they could postpone some of the commitments made or make them entirely non-legally binding, phasing in their obligations on pre-establishment and so forth. So this is the familiar agenda. The essential argument that I'm making is that the problem with both the old treaties as well as the new reformed ones is that they really do not do anything, in my view, to actually promote the SDGs or sustainable development. That is, the first group of treaties relied on the market, on the assumption that if you gave all the rights to the market players, they will automatically invest, and that investment will automatically produce sustainable development through trickle-down economics. That has not worked out quite as intended. That is, there has been progress on economic development, but as the very existence and the troubled history now of the SDGs, here we are just a few years away from 2030, and we're as far away from achieving the SDGs as we have been in the past, and that is actually past COVID, given wars, given the disruption post-COVID. Actually, there have been some backtracking on the SDGs and very little progress on those 17 goals. So we haven't achieved sustainable development through the old-fashioned IIAs. I would argue that the reformed ones are not going to do any better. That is, relying on host states and their own self-interest in being compliant with the SDGs, I predict will not be enough. I think it is not good enough to aspire, as these reformed treaties under this model, to do less harm to the SDGs. That is, to perhaps promote and facilitate better foreign investors that do less harm and permit governments to regulate with more discretion. That presupposes that host states will do all the right things to promote green SDGs. The green investment or SDG-friendly investments. And that my argument, as you'll see, is that these treaties need more radical reform. That is, if we are actually going to use them as intended to promote favorable FDI, then you have to make sure that they actually protect the people in those countries by recognizing the duty to regulate, not just the right to regulate for sustainable development. Why do I think that is so important? So here's just a brief glimpse of the problem. To achieve the SDGs takes money, a lot of money. And so back in 2023, UNCTAD took another look at the investment gap relating to the SDGs. And whereas the first time they looked at this in 2014, that gap was, for less developed countries, 1.5 trillion a year. That is, we were falling short of both private foreign investment flows as well as public ones through the World Bank or aid agencies by a grand total of 1.5 trillion a year in 2014. By 2023, the gap of investment is $4 trillion and growing. And so what that means is that UNCTAD broke this down, and I didn't give you further tables, so that if you take a look at what would it take to have clean water and sanitation, the estimated current investment in 2014 was $150 billion, when what was actually needed was $410 billion per year for a investment gap on clean water of some $260 billion. And you could go through all 17 SDGs, and that's how they came up with 4 trillion. The sad part was that with respect to developed countries, a greater share of that investment gap was being filled through private investors. That is, a funny thing happens. Foreign direct investment seems to go inordinately to countries that need it the least, that is, other developed countries. In other words, it takes great incentives to convince foreign investors to invest in countries they are less comfortable with because of politics, law, or the absence of rich consumers or other factors. And so and the one regime that was supposed to prevent that from happening was, of course, the international investment regime, which hasn't done a good job. And I would suggest the reform ones don't do better. Now, the reformed treaties do at least recognize the need to facilitate foreign investment that is targeting sustainable development. And so if you take a look at something like the recent EU-Angola Sustainable Investment Facilitation Agreement, which just came into force on September 1st, 2024, these are the kinds of things the treaty does. That is, it spends a great deal of time in facilitation methods to make it more transparent, the kinds of regulations an investor would face if they tried to invest. Greater transparency, expediting investment authorizations, licensing, greater coherence across EU and Angola in terms of the regulations so that it's more predictable what the regulations would be in both places, and greater clarity on the desirable investment objectives, sustainable investment objectives that both sides have. And they rely on state-to-state dispute settlement, dispute avoidance, from mediation to arbitration, but not investor-state arbitration as before. So that second hydra-headed monster is gone. And then we correct the first part by basically not having an investment protection agreement at all. So this is not a treaty that is designed to extend any new rights to the foreign investor that is enforceable in international dispute settlement. And that's quite intentional, that we're trying to avoid all the rule of law deficits that I just covered when I put up the two monsters slide. And so this goes a fair way towards trying to reduce some of the barriers a foreign investor might have, but it does nothing to say, even to an SDG friendly, say a green investor investing in green energy, here are some of the reasons you would want to invest, because we're going to protect your rights. We're going to provide you incentives for these rights, and we're going to make sure that you can protect those rights through direct arbitration. And that's what I think is missing. So what I would suggest is that we need to go beyond facilitation to SDG targeted investment promotion, and I would say protection. So how do you do that? Well, the treaties would then suggest that instead of eliminating performance requirements, we permit host states to have performance requirements, provided they do so with respect to SDG-friendly investments, chosen on the basis of whether they would advance the 17 or some of those goals. So that would be accomplished through investment screening, performance requirements, requiring, say, tech transfer, local employment and contact, subsidized infrastructure services, market preferences for SDG friendly investments, assurances that public procurement would be directed in their direction, other financial incentives paired with investor rights for SDG-friendly investors. In terms of home states would also have duties to promote incentives for their outward-bound SDG-friendly investments, and they would require their outward-bound investors to adhere to CSR standards and encourage technical assistance to facilitate implementation of the investment promotion tools. And both of them, that is both investor home states and host states, would establish intergovernmental investment promotion agencies to continuously monitor their policies based on changing technology, changing needs for social and environmental development based on impact statements done over time. Now, the EU-Angola treaty that I just mentioned creates a Committee on Investment Facilitation that goes some way towards creating this kind of infrastructure by and under the treaties. Now, some of this may sound quite wild, but what I would argue, and what I do argue at much greater length in the written versions of this, is that actually most states already have, under existing treaty commitments, duties to do all of these things. That is, if you look at the 189 countries that have ratified the CEDAW Convention, the Convention to Eliminate All Forms of Discrimination Against Women, that convention already says that your outward bound investors have to adhere to the non-discrimination, non-substantive, and that is to promote substantive equality. That directive applies extraterritorially so that your investors already have to do what is stated here under the second one for FDI home states. And of course, the host states have to do much of this, in any case, to promote gender equality. Now, I want to stress the gender equality because the idea that these treaties could actually be tools for gender equality seems to be a little odd to some people. And I would argue it shouldn't be. That is, the World Bank has been telling us for many years, at least in its reports, that there are ways to improve your economic standing and your sustainable development by making sure that you actually protect women in all of these ways. That is, one of the things about the SDGs is a secret that is clear if you look at the data. If you improve the economic posture, if you make sure women are economically empowered, almost all the other 16 SDGs, not just number 5, improve. That is, women's empowerment is key to ending poverty. Women's empowerment is key to promoting and lessening and mitigating the effects of climate change because they're the ones most likely to suffer some of the gravest consequences. Improving the economic standing of women improves health rates, improves virtually everything else. So it is not a small thing to consider these particular aspects that are put on this table, and therefore re-gendering. And the reason I use is, look, international investment agreements are already gendered. They actually prefer men. That is, they are already biased in a way capital is, and if we look at the data, biased against women's empowerment, and the World Bank has considerable data generating this. The reason these particular recipes should be incorporated in our future international investment agreements is because if we now look at the current status of SDG 5, it's in particularly grave state. If current trends continue, over 340 million women and girls will still live in extreme poverty by 2030, the end of the SDGs, supposedly. Between 2000 and 2020, maternal mortality declined by 1/3 globally, from 339 to 223 deaths per 100 live births. But that progress has stalled since 2015, in particular because of COVID and its consequences. Gender equality has also stalled. At this critical midpoint in the SDGs, none of the gender equality indicators are at target or almost at target. A mere 2 of the many indicators are close to target, 8 at a moderate distance to target, and 4 are very far from achieving the target. So I'm not going to, and I don't think we have the time to canvass all the recipes here. I'll be glad to talk about it during the question period, but some is basic, as making sure that you gather the data of the standing of women, including in managerial positions, but also the relative pay for private business and government. That is gendered data gathering. is essential to satisfy, by the way, your CETA obligations anyway. That's what CETA demands. This would mean that a treaty, the investment treaty, would also demand the same thing. This is also, by the way, consistent with the idea that what you put in this treaty should be consistent with what you already have in other treaties. The investment agreements should not in any way derogate from and should support your CETA obligations, which, as I say, applicable to 189 countries already. By the way, 180 countries are parties to at least one bilateral investment treaty. So you can see the potential significance here if you actually make sure that the CETA obligations that you agree to in principle, but are weakly enforced under the CETA Convention, are actually enforced in these treaties. The other things here are also required by your obligations. And by the way, your obligations on gender equality is not just under CETA. They extend to all human rights treaties, ensuring domestic laws, regulations, practices on property, contract, access to credit, achieve and respect substantive equality and are not just gender neutral, are already things you're supposed to do under CETA. To get even more specific, because I think people like to see how it would matter. Well, in international investment agreements typically include some provision for investment promotion agencies in both countries to encourage and facilitate investment, as we see in the EU-Angola commitment. Well, it turns out that the World Bank, way back in 2010, told us that investment promotion agencies are notoriously discriminatory with respect to women. It turns out that female-led enterprises tend to be undercapitalized. They have poorer access to machinery, fertilizer, information, credit, and laws, regulations, and customs restrict women's ability to manage property, start or conduct a business, or even travel without a male's consent. And the investment promotion agencies, in part because they lack female employees and do not consider the fact that in many cases, women are more likely to be the target for bribes, do not respond to these realities. And so back in 2010, this was the World Bank's recipe book for more gender equal promotion agencies. They're sort of obvious requirements. That is, do you have gender disaggregated results in those agencies? Are they regularly reported on? Is gender equality an explicit goal of your investment promotion agency? Is it part of the major planning documents that you have for your investment agencies? Are there measurable indicators of success? What I'm suggesting is if you take seriously these obligations, as you should because you already have them under your treaty obligations, this should be part of the requirements for an investment promotion agency in my version of SDG-friendly bilateral investment treaties. So this is the brief summary of my argument because I know I'm running out of time. Basically, we've had lots of experience with international investment agreements on the premise that deregulation and privatization will lead to economic development for all. Post-1999 in particular, we became more aware, and there's been a growing backlash that this is not necessarily the best recipe for economic development, and that they unduly constrain states' right to regulate. And the response has been, yes, let's restore the right to regulate by rebalancing these treaties. And the core premise has been that if you restore the sovereign right to regulate, this will itself advance sustainable development. Well, we're now learning, post-2015 certainly, that there's a huge investment gap. And I'm afraid it's not coming, even under the reformed treaties or under the old treaties. And therefore, neither the reliance on the free market in and of itself by traditional international investments agreements, nor blanket regulatory freedom under reformed international investments agreement will likely attract foreign investors. When I talk to clients of foreign investors, they tell me they can't rely on something like the EU-Angola agreement or the African continental investment promotion, the rights they're given are too small. They'd rather contract around them if they can to get to arbitration. And therefore, that's one of the reasons why I think merely relying on the right to regulate as the key has to be replaced by the duty to regulate. And this would mean a paradigm shift in how we think about what these treaties are for. That the key thing on this slide is to recognize that these treaties are for recognizing, protecting, and enforcing the home and host states' duties to respect, protect, and fulfill the underlying rights that are essential to sustainable development, and right now the SDGs. And we need to reframe the investor rights, host states derogation clauses to advance those in a serious way and promote them. What I don't have time, as I thought I wouldn't, is all the many reasons why this is an academic talk and not a talk in Uncentral on actually what we need to do to solve the problem. That is, the political dynamics are such that states very much welcome the idea that, hey, these are treaties to protect my rights. And I'd rather have those, thank you very much, than any additional treaty that recognizes duties that I may have academically accepted or hypocritically accepted in human rights and environmental areas. And there are many, many political reasons why this particular version of reform for the international investment agreements has taken hold. My only hope in advancing this is that if we can change the types of groups who are in favor of these treaties, because by convincing them that these treaties can actually promote good investments, SDG-friendly investments, if we can convince them that that's really the purpose of these treaties, then perhaps we don't have to exclusively rely on business as the demanders of these treaties, but we would find international civil society and other advocates for these treaties. Right now, there are no such advocates for these treaties among those kinds of groups. The view that they are the two hydra-headed monsters prevails, and that's regrettable. Thank you for listening.
Thank you so much, Professor Alvarez, for the lecture. And we're going to now immediately proceed to comments from our discussant, Professor Qureshi. Professor Alvarez, may I kindly ask you to click the stop share button? And then, okay, great. Thank you, Professor Alvarez. Professor Qureshi, I think you need to click at the bottom share, the share tab, and then your PowerPoint.
Okay, how do I go into my my files here? Just 1 second, let me take it out.
Sure.
Yes, here. Okay. So share. And, here. Okay. Okay.
Yes, we can see that. Yep.
Great. Professor Alvarez, thank you very much for this thought-provoking, stimulating talk. And I read with great interest your extensive paper. And in fact, my comments are based on your written paper. I think that there are nuances and that are perhaps in your talk that may not have been that clear in the paper, if at least I saw. But there, it is not possible to disagree with what you have written. However, as a discussant, what I would say is I can think of two different ways of responding to your paper. And myself, I'm not clear as to which spectrum of those two opposing viewpoints I stand at the moment. So the two different viewpoints, I think one can reflect upon is firstly to consider this as essentially a US-centric perspective on SDGs and their role in investment agreements, and secondly to regard them as very appropriate suggestions, as you have made, but with perhaps some comments to reflect upon, if I could put it that way. So what do I mean by a US-centric perspective? I do mean this in a negative way, in the sense of a US one world view of development objectives and methodology in their implementation. And what is the basis of suggesting that? It is that, firstly, your characterization of the backlash to investor protection-oriented investment agreements as being essentially concerned with expanding the scope of the host state discretion rather than rendering effective SDGs is maybe considered a bit unfortunate in the sense that I ask you, is consolidating host state discretion not a necessary precondition for an effective implementation of SDGs? And second, is it appropriate to assume that host states are incapable of exercising their discretion responsibly? I mean, sitting in China here, one is very conscious that China has made significant progress in the elimination of poverty, internationally recognized for its performance there. Secondly, there is an assumption that the 2030 SDG package is beyond reproach itself and is an appropriate agenda to follow within the framework of international investment agreements, to the exclusion of others. It is, of course, in reality, a vision of the West, one might say, as to how developing countries should prioritize their development. Developing countries, developing host countries may well have different priorities and may have good reasons for having different priorities. Might one disagree with the calibration of the universal consent to the SDG goals that you attribute to? You have, of course, in your talk explained that these are very much in the nature of soft law. But the gist of your talk, however, I wonder, is reading too much in the universal consent to be exclusively concerned with them in achieving country development objectives. Fourth, the fact that the nature of SDGs and the question of their implementation is such that SDGs can easily be hijacked to achieve certain specific goals. As we all know, the substance of law is set not only in its letter alone, but also in the manner of its implementation. The fact is that SDGs are self-contradictory, are not necessarily clear and precise, as you have alluded to, but are not set in any hierarchical order. For example, to read into these, the opportunity to emphasize gender equality, however commendable and necessary that goal is, might be considered an arrogation of the malleable nature of SDGs to push and shape a particular set of priorities, which objective some countries might observe is more nuanced and clear and needs to be set against their levels of economic development, their national priorities, and particular circumstances. In the same way, a machinery intended to effectuate the SDGs based on a set up that allows all manner of stakeholders, including NGOs, to influence their implementation, leaves the shaping of a hierarchy to the weight of the voice of the concerned shareholders, and thus undermining the capacity of the host state to order its own development priorities, let alone its capacity to effectively explain its stance. The other view, the investment-centric SDG approach that you take, um, uh, is one that one might say is appropriate, absolutely. States, whether the United States or developing countries, simply cannot be trusted to bring any meaningful changes that affect us all so profoundly in matters relating to sustainable development, including gender equality. The SDGs can be realized only if they were made effective both in home and host states of investors. So, however, I'm just wondering why there wasn't sufficient discussion or discourse about not the sustainable development goals and their nature, but the status, legal status of sustainable development in international law. One would have thought that in a focus that is concerned about making sustainable development goals more effective, that some reference of that even if by way of background, would have been useful. As you know, the General Assembly has asked for an advisory opinion on the responsibilities of states in respect of climate change. So there is some merit in probing here on the question, the status of sustainable development in customary international law. Um, I realize that there are different views on that as we sit. The other point to make is, should one consider other options for implementing Sustainable Development Goals? I'm not sure if you're aware, the IMF in its surveillance exercises, in the consultations it engages annually with member countries, now has gender equality and climate change as a consideration to discuss with member countries. I wonder if how that fits in with your vision here of investment agreements as being the sole vehicle for the implementation of sustainable development goals. The third point is the overcrowding of investment agreements. Is there a danger that your suggestions overcrowd investment agreements or define the nature of investments exclusively through the prisms of SDGs? The consequence of imposing obligations on host states and home states involving the achievement of SDGs is, I think you recognize, a dirigist approach to international investment that may or may not fulfill the goals of national development plans or the goals of investors. Would private investors in such circumstances be inhibited in investing through an SDG prism completely? And what about the asymmetry in SDG burdens as between a state investor and a private investor, and the burdens on the host state and the home state in sharing responsibilities of explaining their respective narratives on the implementation of SDGs? These are minor points, I think. But lastly, on the question of regendering international investment agreements. At the outset, I would emphasize again, I'm not anti-regendering, and I commend you for taking up this particular clause throughout your paper. I simply want to affirm that perhaps there is a need for a more measured, analytical, objective approach to achieving the SDG goals as a whole, and for the benefit of all relevant stakeholders and concerned parties. To this end, I would state that there is a need to reflect more carefully whether indeed there is consensus that gender equality is, to quote your paper, widely considered key to the entire SDG effort. The assertion that gender equality matters across all SDGs is distinct from asserting it is a prioritized SDG under the UN apparatus. The assertion, again to quote it is widely accepted that achieving equality between men and women is vital to the success of virtually all other SDGs, may be technically correct, but controversial if it is understood as implying that amongst all the SDGs, it stands as the most important goal to be achieved and prioritized. Taking this approach unreservedly could have the effect of blinding us to the possibility that there may be other root causes and more effective and complete ways of achieving the SDG goals, regardless of gender prioritization. So Professor Alvarez, thank you very much for your talk. I enjoyed it, and I probably agree with you, then disagree with you. Thank you.
Thank you so much, Professor Qureshi, and